From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Senate Democrats hold their hearing on Supreme Court ethics. But what kind of rules do they actually want to impose on the justices? Plus, West Virginia Governor Jim Justice announces he will run for Senate in 2024, putting Joe Manchin on notice. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnist Kim Strassel and editorial board member Monet Ukwe-Barua. Let's start with a clip from the Judiciary Committee hearing yesterday. This is a montage of Senator Sheldon Whitehouse of Rhode Island, his opening statement, giving his theory of the case, where he refers to some hospitality that Justice Clarence Thomas has received over the years from his longtime friend, Harlan Crow.
We are here today because the Supreme Court is playing out of bounds of the ethics rules for federal judges. Justices read the ethics rules in unique and eccentric ways, and when they're caught out of bounds, they refuse to allow any investigation of the facts. Some of this personal hospitality involve people dedicated to turning the court into a tool for right-wing billionaires. Until there is an honest ethics process at the Supreme Court, these messes will continue. The court has conclusively proven that it cannot police itself.
Kim, what did you make of the hearings? I mean, the thing that sticks out from Senator Whitehouse there is, does he really think that there is some secret campaign to make the Supreme Court a tool of right-wing billionaires? That seems a little conspiratorial to me.
A little, yes. I wouldn't really trust anything that Sheldon Whitehouse says. Let's step back here for a second and just put this all in context. Essentially, Democrats called this hearing because they and the media have made a fuss in the last couple of weeks over some issues of whether or not Justice Clarence Thomas and Neil Gorsuch fully disclosed certain things which have been rectified by the justices. It's not really a big deal at all, but this is their moment. They have been wanting to delegitimize the court for a long time. They want to soften it up to try to pass one of these ethics proposals that they have and impose new rules on the court to hem it in, or they want to soften it up so that at one point, if they one day get the ability to get rid of the filibuster, they'd like to pack the court. This all goes back to their continued fury over the fact that there are now 6 conservative justices on the court, which are increasingly issuing rulings that the left doesn't like. It has nothing to do with the behavior or standards of the justices. So you saw Sheldon Whitehouse, you saw Dick Durbin wringing their hands and suggesting that there's nothing more important than public trust in the court, even as they diligently worked to destroy that public trust in the court. And then on the other side of this hearing, you had Republican senators and also some very good witnesses pushing back both on the substance of the accusations, but also on the very real threat some of these so-called ethics bills pose to the constitutional separation of powers.
Well, the second of those is what I thought was notable in this hearing, what stuck out to my mind, because there has been a lot of media coverage of the supposed allegations against the justices, and they vary in how risible they are. The latest is some stories about how justices teach law students over the summer and get compensated for that, and sometimes those courses take place in Europe or in nice places. I think that everybody already knew that, or anybody who was paying attention would have known that anyway. These are not secret courses. They're publicly announced. This is a long time practice. But Monet, it seems to me that there has been much less focus on what Democrats actually want to impose on the Supreme Court. And that's why I would recommend, if people want to get any sense of this hearing, I would go watch the 7-minute opening statement by Thomas Dupree Jr. He's a lawyer, former principal deputy assistant attorney general. And he took issue with a couple of these things that are in Sheldon Whitehouse's bill, his Supreme Court ethics bill, starting with the idea that there would be some sort of a complaint process for the public to lodge complaints against Supreme Court justices, and then those would eventually be adjudicated by panels of lower appeals court judges. Listen to this.
These proposals for an ethics investigations counsel or a designated ethics officer would damage and debase the institution by encouraging frivolous and politically motivated attacks on the court's integrity. If you don't like the outcomes of particular cases, well, attack the ethics of the justice with whom you disagree and force them to post your accusations on their website.
He also took issue with the idea of congressionally imposed rules on recusals for Supreme Court justices, essentially saying that that would be easy to game. Listen to this.
Adopting these measures would open the door to a tidal wave of disqualification motions in virtually every important case. Round one in all the big-ticket constitutional cases would be litigation over which justices are even eligible to hear the case. Here, too, it is hard to imagine anything more corrosive to public faith in the Supreme Court than what would become routine volleys of motions alleging that various justices are ethically compromised and must recuse because they accepted a meal from someone distantly connected to a case.
Monet, to my mind, those seem like real concerns, and there's all these bills that Democrats are floating to impose some kind of ethics rules on the Supreme Court. And as I said before, it seems to me very little discussion so far on how those things are actually supposed to work.
Right. I couldn't agree more that Thomas Dupree gave a great opening statement describing the harms that would be caused by some of these restrictions that Democrats in Congress want to place on the Supreme Court. It really does get to the heart of the separation of powers and Supreme Court's ability to operate independently as its own branch of government in competition with Congress rather than subjected to it the same way that, say, executive agencies are subjected to congressional oversight. And so provisions in White House's bill, like having a formal complaint process for Supreme Court justices, the idea is that if they are suspected of some kind of wrongdoing, some kind of improper relationship, that private parties would be able to file a complaint, which then, as you mentioned, would be investigated by a random selection of lower court judges. Essentially, this would be making it such that the confirmation process for the justices continues indefinitely. That same process that Americans have gotten used to now, which began probably with the appointment of Clarence Thomas and also Robert Bork, in which the opposite side is trying to dig up any potential impropriety in the entire life of the judge to that point, would continue once the justices are on the bench, because at any point, anyone skeptical would be able to raise a potential complaint, and it would have to be publicly vetted. And there's no guarantee that the lower court judges who are tasked with vetting this complaint would do so in a neutral way. So it would turn the court into a circus. And I think a lot of Democrats, as you've mentioned, often point out that Congress does have some oversight authority over the court in terms of determining the number of justices who sit and the number of justices necessary for a quorum. But there's a big difference between the sort of questions of composition of the court and the court's procedures. And the Constitution is quite clear that the Supreme Court does act in certain ways as the head of an entire separate branch of government and has control over things like its calendar, has control in many ways over its own scope. And it would be a big breach of that historical distinction for Congress to mandate certain procedures for the Supreme Court that haven't previously existed. And so Dupree did a very good job of laying out all the ways that there's one thing between Democrats attempting a public campaign to delegitimize the court. I don't believe that they're right to do so, but it's their right. But if they want to create formal structures which restrict the activities of the court, they would be overstepping the Constitution's bounds.
Well, let me throw that question to Kim, because that also became an issue in this hearing on the idea that Congress could force the justices of the Supreme Court to write an ethics code. And that's another part of this White House bill. It says not later than 180 days after enactment of this section, the Supreme Court of the United States shall, after appropriate public notice and opportunity for comment, issue a code of conduct for the justices of the Supreme Court. And the Republican argument here is that that is treating the Supreme Court like any other bureaucracy in the executive branch or department that Congress can say, we are ordering you to write this rule and go through the typical notice and comment process that everybody understands from administrative law, and that the Supreme Court is different. The Congress cannot command the Supreme Court in that way. But as Monet says, the Democratic argument is, hang on, the Constitution sets up a Supreme Court and says that the judicial power of the United States shall be vested in it, but is pretty open-ended other than that. It doesn't say how many members it's going to have. And so the Democratic argument is that there are all sorts of non-substantive, non-merits, non-case-related issues that don't reflect on the Supreme Court's judicial judgment, but that Congress is perfectly capable of setting up some processes and procedures as it has.
Yeah, I profoundly disagree. And until recently, pretty much every legal scholar would disagree as well, too. If I can think back to my Article 3 language, I think it's the judicial power of the U.S. shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time order and establish. Now, what most legal scholars over the years have understood that to mean is that this gives the Congress some ability to lay out the size and structure and number of courts so that courts can be able to handle caseloads, for instance. And that this is why Congress has the ability to occasionally change that size or structure as the country grows. It's also why Congress over time has also created other inferior courts to the Supreme Court. That's why we have a federal court of international trade. It's why we have bankruptcy courts. It's why we have the court of claims, because as more and more cases have come to be in the United States, they needed to figure out a way for the judicial branch under the Supreme Court to handle things more efficiently. But there is the importance here from a legal perspective and a scholarly perspective is that the Constitution is pretty clear that it gets to order and establish more courts. It does not say that it gets to tell courts how they have to operate. And that was where we got some really good testimony, both from Thomas Dupree, who you mentioned, but also I would recommend people go and listen to Judge Mike Mukasey, former federal judge, a former attorney general. He also gave some excellent testimony. Talked about the incredible importance of the separation of powers, the very idea that this entire country was founded on the notion that we needed three separate branches that were separate and distinct. And he pointed out something really interesting, Kyle, which I thought was very important. He said, pretty much these bills that are out there, the ones that are ordering the court to adopt their own code of conduct, they are acknowledging by the fact that they're telling the court to do it, and that they are not themselves writing one and imposing on the court, that Congress doesn't have that ability to do that. And he said, by extension, if you have acknowledged that you don't get to write a code of conduct for the court, you also don't have the power to demand that the court adopt one itself. Not to mention all of these other kind of crazy rules that they actually are outright trying to impose on the courts, like recusal standards or some system whereby people can file complaints that will be made public and set up these judicial investigation panels to look in them. There's simply no authority there. That was what really struck me, is just how serious the separation of powers issues is and how lightly Democrats brushed over that throughout this whole hearing.
Monet, I like the way you put it earlier that this complaint process would sort of keep the confirmation hearings rolling at all times for all 9 of the justices. The White House bill says the Supreme Court of the United States shall establish procedures, skipping over some legalese here, under which individuals may file with the court complaints alleging that a justice of the Supreme Court has violated the code of conduct, has violated federal law, or has otherwise engaged in conduct that undermines the integrity of the Supreme Court, which is an incredibly broad phrase. And Supreme Court justices, as do other federal judges, have life tenure. And there's nothing that Congress can do short of a constitutional amendment to change that. But maybe another way to put it would be that this sort of complaint process would be an open-ended impeachment hearing at all times, inviting complaints to come in and circulating them and publicizing them and putting them before appeals court judges, sort of smoothing the way to an impeachment of any justice that anybody wants to argue made some sort of slip up of code of conduct or otherwise undermining of the Supreme Court.
Exactly. I think that you're right to point out that the language in the White House bill is extremely vague. The code of conduct that they're demanding the Supreme Court create for itself suggests that justices can be censured in some way for conduct that undermines the integrity of the court, and there's no specific definition for what such conduct would be. And so we can all speculate about the ways that this would be abused. But I think it's also important to point out that we don't have to speculate all that much. We know exactly how it would be abused because of the false alarms that Democrats have raised in the past few weeks regarding Clarence Thomas. So Clarence Thomas has a friendship with Harlan Crow. He has a friendship with Leonard Leo. These are two figures who are donors to certain conservative causes, who are important players in conservative and Republican Party efforts. But Neither of them has ever been accused of having pulled a specific string with Justice Thomas or anyone else to manipulate an outcome of the court. Neither of them brings business directly in front of the court. And yet Democrats have drawn these massive overinterpretations of Justice Thomas's relationships with these and other figures and suggested that there's something improper merely about his reception of gifts or the relationships themselves. And so you can only imagine if once there were a structure in place to mount complaints about justices' conduct in their private lives, that we would be seeing episodes like this, Justice Thomas's ordinary dealings and other justices being turned into the grist for formal complaints and pushes for recusal. And that seems completely out of bounds in terms of what has traditionally been expected of the justices. There isn't a real clear reason why Justice Thomas and anyone else can't fulfill their duties to the court while also engaging in responsibilities of these or in relationships of these kinds. And so it's almost as if the Democrats have shown us exactly how they would abuse these sorts of protocols and restrictions if they were able to pass them into law.